when you're drafting a will, you say how important it is to really be specific, not only when you're talking about your assets, but even things like your funeral arrangements.
Yes, you can do that. You can say how your body want to be cremated or buried. You can even name where you want to be buried. Of course, subject to how you're going to find a burial plot, because in Hong Kong, actually, it's very difficult to find burial plot. The only thing is that we do not advise our client to make it too complicated, because assets do change from time to time. For example, today you have a watch, tomorrow you may have gifted this to somebody else. That would cause confusion, and you don't want the will to be reviewed every 5 years or something like that.
So what are you supposed to do? How do you avoid that?
To make it as general as possible, and if there's any specific instructions, all you can do is to have a second document like letter of wishes. It's not part of the will and it's not a legal document, but you give you directions to the executor who is going to handle your estate on how to distribute some of your memorabilia, some things of a sentimental value, to the people that things will be benefiting from it.
So actually the will itself should be a bit more general, and then if you have specific instructions, that's a separate document entirely.
Yes, I think so. And the will should only be reviewed upon life event. For example, you get married, you get divorced, or you lose some of the family members, and there's a substantial changes to your circumstances.
Yeah, that's the time to revise. And then what about if you have young children?
Oh, young children is particularly important for a will to be in place. And on top of it, because you want to have someone to look after them in case you cannot look after them anymore and they're young. So you have to appoint a guardian. But it is not advisable to put it in the will, because your guardian, you do not want your guardian to assert their guardianship through your will, which will be probated together with a list of assets and liabilities. It's better to have it as a separate document called the appointment of guardianship, appointing someone as your permanent guardian, or probably someone as a temporary guardian as well, to look after them. And then in your will, you have a trustee to look after your family wealth for their benefit until they attain a certain age.
Obviously, nobody ever expects to be in a horrific accident or go into a coma or have an illness where they're not able to make their own decisions. But where does a living will come into play?
When you make a living will, unfortunately, Hong Kong is no such thing as a living will. Living will is a very, very common concept in the Western countries, but in Hong Kong, the closest thing that we have is an enduring power of attorney. That document provides an attorney to look after your financial affairs when you are under. That has to be prepared in a stipulated form and signed in front of a lawyer and a practical practitioners. And it has to be registered in the High Court before it will be having legal effect. But it has nothing to do with your general welfare. If you want to appoint someone to make a decision for you in case you're under, then the closest that you can do is to have an advanced health directive. But yet, this is not a legal document, so there's a possibility the doctor may not
may not actually follow the instructions.
May not follow the instructions. And then, even if they follow the instructions, it's very limited. It's only about whether you want to receive life-sustaining treatment, which is very, very limited comparing with whether you want to receive a surgery or other decision that is sometimes has to be decided on the spot, and you cannot appoint someone to make the decision for you, no matter how close that person is to you.
Bottom line, though, you need to be prepared. If there's a will, there's a way.
Correct. You need to be prepared. If there's a will, there's a way.